Next, we are going to hear Professor Paul Nemitz, who is a principal advisor to the EU Commissioner for Justice, and he will talk about the judicial scoreboards and the criteria of efficiency and quality of justice as manifested in the scoreboard. Thank you.
Honorable presidents of the conference, honorable members of the audience. Thank you very much for inviting the European Commission to be present in this important academic conference. And I would like to speak in this session about the two reports which the European Commission regularly produces, which cover the independence of the judiciary, namely the Rule of Law Report and the Justice Scoreboard. Both of these documents are published annually by the European Commission. The Justice Scoreboard is the factual basis. It analyzes situation in the member state, then for a political assessment, which is produced in the Rule of Law Report. Both of these documents, but in particular the Rule of Law Report, are subject of political deliberations in the European Parliament and in the Council of Ministers, in particular the Justice Ministers, but sometimes also the General Affairs Council of the European Union, which represents the governments of the 27 member states of the European Union. And both of these legislative bodies also come to political conclusions on these reports, which then lead to action of improvements, let's say hopefully, in the member states. The EU, of course, is based on a set of shared values, including respect for fundamental rights, democracy, and the rule of law. And these values mean that the rule of law is not only an integral part of our democratic identity in the EU and the member states, but it is essential for the functioning of the EU, namely for the citizens and business trust in public administrations, but in the form of the primacy of the EU law, also to maintain the good functioning of the internal market. While member states have different legal systems and traditions, the core meaning of the rule of law is the same across the EU. The key principles of the rule of law are common to all member states. Legality, legal certainty, prohibition of the arbitrary exercise of executive power, effective judicial protection by independent and impartial courts respecting fundamental rights, the separation of powers, permanent subjection of all public authority to established laws and procedures, and equality before the law. All these principles are enshrined in national constitutions, translated in legislation, and find themselves also in the Charter of Fundamental Rights and the Treaty of the European Union. The case law of the Court of Justice of the European Union on the rule of law and judicial independence provides a clear set of legal requirements which member states have to follow in their rule of law related reforms. Respect for the rule of law entails compliance with EU law and the principle of primacy of EU law, which is a foundation of the EU. In the annual law report, rule of law report of this year, which was published on the 20th of July, we have again looked at independence and first of all perceived independence of courts across the EU. And independence, quality and efficiency are essential parameters of an effective justice system, whatever the model of the national legal system and tradition in which it is anchored. The independence of national courts is a necessary condition for ensuring effective judicial protection and obligation for member states under the EU treaties. As reaffirmed by the Court of Justice of the European Union, the existence of effective judicial review designed to ensure compliance with EU law is of essence for the rule of law. Effective justice systems are the basis for mutual trust, and This is very important that we also look at each country. We have 27 country chapters attached to our annual Rule of Law report, in which we look in detail at parameters of judicial independence country by country. Now we go a little bit to the factual basis according to the EU Justice Scoreboard, which was published on the 8th of July 2021. We can see that in comparison to 2020, the same member states continue to cluster around a higher and a lower end of the scale of perceived judicial independence. Among the general public in Austria, Finland, Germany, and the Netherlands and Luxembourg, the level of perceived judicial independence remains very high, above 75%, while in Croatia, Poland, and Slovakia, the level of perceived judicial independence remains very low, namely below 30%. The 2020 Rule of Law report noted that in a number of member states, steps are underway to strengthen judicial independence and reduce the influence of legislative and executive powers in the justice system. The important role of the councils for the judiciary in safeguarding judicial independence is increasingly recognized. The new councils for the judiciary established in Ireland and Finland are now operational. In Luxembourg, the proposal to establish an independent council for the judiciary has been progressing. In Sweden, the Commission of Inquiry on the strengthening of protection of democracy and the independence of the judiciary continues to work and intends to propose legislative and constitutional reform in 2023. In other member states, similar work is going forward. Now, the methods for appointment of judges is also crucial in terms of the independence of the judiciary. The Court of Justice of the European Union has clarified that under EU law, in order to guarantee judicial independence, substantive conditions and procedural rules governing judicial appointments must prevent reasonable doubts as to the impartialness of the judges concerned to external factors as to their neutrality as judges. Since the last report in 2020, reforms to strengthen the appointment procedures for judges have continued in several member states. For example, in Czechia, a law was adopted and a transparent and uniform system of appointment of new judges has been put in place. In Latvia, new appointment procedures set up last year are now being implemented and applied. And in Malta, the comprehensive reform of 2020 are now in place and also are being applied, and they have contributed to the strengthening of judicial independence. We need to ensure accountability in the judiciary and safeguarding judicial independence also in disciplinary procedures. A number of member states have strengthened the integrity framework for judges and prosecutors. In Belgium, the integrity framework has been strengthened by applying general ethical principles to all categories of members of the judiciary. In Austria, a comprehensive compliance management system is being implemented for courts and prosecution services, and in Latvia, I already mentioned, a new code of ethics for judges was adopted. And there are many other examples of such improvements in the European Union. But judicial independence remains an area of concern also in some member states. They vary in intensity and scope. Serious structural concerns exist in a few member states and have deepened, while challenges of a lesser nature in other member states still require attention. In a few member states, the direction of reform has been towards lowering safeguards for judicial independence. These changes have given rise to serious concerns, which have aggravated in some cases. As they have led to increasing influence of the executive and the legislative branch over the functioning of the justice system. Reforms of disciplinary procedures and of liability of judges raise particular concerns. And I don't need to go now into the detail relating Poland, Hungary, and Romania, but it is clear that in these countries we have a number of judgments already on the table by the European Court of Justice. We have infringement procedures by the European Commission. And the problem of independence of the judiciary doesn't stand alone. In all three countries, we see other symptoms of a backsliding, not only from the rule of law, but also from principles of democracy. And so it is important that both individuals and institutions in these countries and relating to these countries stand up for the independence of the judiciary, but also for other important elements of a well-functioning rule of law system and a well-functioning democracy. The Court of Justice continued to develop its case law on the rule of law, notably in relation to the treaty's requirements that member states are to provide remedies sufficient to ensure effective legal protection in the fields covered by union law, where the Court of Justice has further clarified the guarantee of judicial independence under EU law. Through the preliminary ruling mechanism, national courts continue to bring rule of law relevant questions to the attention of the Court of Justice. It has ruled on requests for preliminary rulings on the rule of law related to matters presented by courts for Malta, Poland, the Netherlands, and Romania. These rulings were related in particular to judicial appointment procedures and the execution of the European arrest warrant in the context of deficiencies as regarding judicial independence in a member state, the disciplinary regime for judges, the personal liability of judges, the creation of a special prosecution section dealing with judges, and the principle of primacy of EU law. The cases in question, you will find them in my contribution, which I have submitted. The Commission, in this context, continues to exercise its role as guardian of the EU treaties by launching infringement procedures where necessary. In some specific cases, the Commission has even requested interim orders by the Court of Justice to prevent irremediable harm. Besides infringement procedures, Article 7 of the Treaty of the European Union provides the more general procedure for upholding common values of the Union, including relating to the rule of law and thus also the independence of the judiciary. The European Council remains seized in two procedures brought by the Commission against Poland in 2017 and by the European Parliament against Hungary in 2018, with a view to determining that there is a clear risk of a serious breach of Union values. In September 2020, the Commission updated the Council on the last developments in the areas covered by these recent proposals. In June 2021, the Council held hearings for both Hungary and Poland. The rule of law and thus the independence of judiciary is also a precondition for the proper management of EU funds, and in May 2018, the Commission proposed a new budgetary framework with a legislative proposal for a dedicated mechanism to protect EU funds against risks arising due to the rule of law breaches in individual member states. This regulation was adopted in December 2020, and the Commission is fully committed to enforcing this regulation and is actively working on its application. The rule of law is also prominent in the implementation of the Recovery and Resilience Facility. The Member States' recovery and resilience plans include important reform priorities such as those relating to the justice system. and the European Commission is providing technical support to member states in this area. And in my written contribution, I also refer a little bit more to our work on international cooperation. Obviously, the European Union is not only the biggest observer of elections worldwide. Wherever we are invited to observe elections, we finance this and do this. But we are also a very important donor and a very important provider of technical assistance when it comes to policies relating to fundamental rights and the judiciary the world over. So much my contribution on the independence of the judiciary. Thank you very much.
Thank you. Thank you for a fascinating presentation.